Well, good morning, everybody. Hope everybody's having a great Monday. Thanks for joining us this morning for this latest in our series of town halls. Very excited today to have the Maryland Insurance Administration joining us for a town hall here about notaries and title insurance producers and independent contractors. What's the difference? Two very different things. Related but different, and important to understand that they're different things. And I'm here today, as usual, and also joining me today is Miriam David, the Assistant Chief of Title Enforcement for the Maryland Insurance Administration's Fraud and Enforcement Division. And we're going to cover a little bit about what we're here to do and what we do for notaries and what it takes to be a notary, and then transition into what it takes to be a title insurance producer. And it's a topic we get asked about a lot in our other town halls. One of the most frequent types of questions we get are actually title insurance producer questions. So we thought, why not have a town hall about that? And we did last year, and Miriam was great enough to join us last year, and we welcome her back again today to do this one again, as was a pretty popular town hall from last year. So we're gonna do this one again, and hope everybody learns something from this. First and foremost, just kind of covering the ground rules like we normally do to start here. It'll be a little different this time, but in general, the same thing, right? We're gonna the information here presented today by us for informational purposes only. It is not intended to be legal advice. Informational purposes only, not intended to be legal advice. By joining us today, you are consenting to being on this recording of this town hall. The recording for this town hall should get posted online, usually within a week or so of the town hall's occurrence. So sometime in the next week or so, this will pop up on the Secretary of State's notary page on our website, and for you to view at any point in time thereafter. And you can still view last year's too if you want, and this one will ultimately replace that one. But questions, throw them in the chat box as usual. Got somebody from the Secretary of State staff that'll try to answer those questions. I always say it, hopefully everybody abides by it. Ask questions in the chat box. Don't answer other people's questions in the chat box. If you are with the Secretary of State's office, go ahead and ask those questions. Answer those questions. But if you're not with the Secretary of State's office or the Maryland Insurance Administration, do not use that chat box to answer other people's questions. Sometimes we have very well-intentioned folks that don't always give the right information for the answer. So let the Secretary of State's office or the Maryland Insurance Administration answer those questions in the chat. Please ask there, but do not answer there unless you are with us or MIA. So I think I've covered that point enough. At the end, we're going to take some of the frequently asked questions in the chat and read them out loud and answer them. And whether it's a Secretary of State question or Maryland Insurance Administration question, rather than just kind of having at the end, we'll have a slide with email addresses for us in the Maryland Insurance Administration. If after the presentation and after we read off those chat questions, we still haven't answered your question, we'll ask that you reach out to us by email, and we'll get back to those emails here the next day or so, so that everybody can have their question asked and answered and be heard, while also respecting everybody's time here, trying to keep this to an hour as much as possible. So with all that being said, I think it's time to get started. Thanks again for joining us, folks. And here we go. So like the usual town hall, we start with our sources of authority for the Secretary of State's office. You see them here: State Constitution, Annotated Code of Maryland regulations. These are the places where the information drawn for today's town hall are taken from. And so you can find a lot of these answers here in the law and in the regs. We're a big fan of following the law. We ask you to follow the law. We do it ourselves. And Maryland Annotated Code, Title 18, Subtitles 1 and 2 are where you find laws pertaining to notaries that we deal with, and the Code of Maryland Regulations 010208, .01 through 17 for the regulations that we regulate. Some useful links. Scroll for a second on this page, and remember it's getting recorded, so if you don't write them all down, you can get these pages by watching the recording as well. If you learn anything from this town hall, ask us questions if you have questions, and go to our website. And if you want to find the information, website is sos.maryland.gov, SOS like Secretary of State, .maryland.gov. And you'll see a bunch of links that start with sos.maryland.gov. Namely, the first one, the Notary Division homepage, ordering the handbook if you want to order a handbook, direct links to the law itself and the regulations where you can find them. And also, one of the biggest questions we get asked after these presentations, folks got an invitation that kind of jogs their memory. Oh yeah, I got to renew, or I just expired and need to reapply. How do I do that? Those two links there, new notary information and renewing notary information, walks you through step by step how you apply to become a notary or how you renew your commission, including the links to the information you need for each step, should there be a link with additional information for that step that is needed. And then also our frequently asked questions page. We get a lot of questions, as you can imagine, over the years, and the ones we get asked a lot, we try to put onto that frequently asked questions page. It's always work in progress, so if there's a frequently asked question that isn't covered there, or you think it's frequently asked, let us know, and we'll try to get it online too, if it's something that we can deal with. So these links here, these are your main places. If you're trying to find notary information, this is where you want to go. Tell folks all the time. The most common responses I get is, I saw somewhere online that you can do X, Y, and Z. And the first question I ask them is, where? And if the answer isn't your website or town halls, or I talked to one of the approved education providers, I'm always cautioning that info, right? You want to go to the sources that can be trusted, not some random chat or something online where people will tell you anything. Maybe even another state's laws, right? You might be able to do something as a notary in one state that you can't do in another. So it's important to know the sources of that information and how valuable that source is. And these are the sources that are straight out of Maryland law, right? We're the ones that regulate it. We give you the commission. So we know what the requirements are to become a notary, and then generally when notarizing, what should be done. And so always make sure you're going to places that are credible, that have credible information, and you can trust, rather than just some random chat forum online where you may or may not get the best info and advice. And as somebody that used to notary complaints back in the day, in my younger days, I can tell you a lot of the folks I talked to, they took advice from one of those random forums. So they could do all kinds of fun stuff rather than what the law actually says. So check with the verifiable sources first before acting if you have questions. So just about becoming a notary, we have an entire town hall about the application and renewal process. We're going to touch on it briefly here just to try to outline and draw a distinction between the differences of becoming a notary and becoming a title insurance producer. This is, if you've renewed or applied in the last year and a half, you've seen this page. This is the landing page for where you'll do pretty much everything as a notary when it comes to your commission, whether it's applying to become one, or renewing it, or updating your information. If you maybe change of address or phone number or email, you would update your information, checking the status of a submitted application. If you wanted to become a remote notary, file the form to become a remote notary, or just if you wanted to find out if somebody's a notary, you could search them on the database and verify that they are a notary right at this page. We're also qualifications to become a notary: at least 18 years old, good moral character and integrity, resident of Maryland or employed or have a practice in the state, So if you're living in Maryland, you're going to be a resident of a certain senatorial. Um, if you reside outside of Maryland, you have to be a resident of a state that allows Maryland residents working in that state to serve as a notary in that state. So as far as I know, all the border states do, right? The requirement is that if you're not living in Maryland, is that you be employed or have a practice in the state. So folks say, well, I live in I don't know, pick a state, Virginia, right? And my company has an office in Maryland and I work there. Well, you're employed in the state, right? You have a place of business in the state of Maryland, or a practice in the state of Maryland. So that type of situation, it would qualify. So a resident of Maryland, or employed, or have a practice in Maryland. You can renew if you're renewing, you can renew up to 60 days prior to your expiration date, or within 30 days after your expiration date. Right, so you got a 90-day window there in which you can renew, 60 days before your expiration, up to 30 days after. It's a good long window. Folks that are renewing, you need to take a course of study every time you renew now. Take that course, excuse me, take that course of study right before, within that window. Folks sometimes will ask us, well, I took a course 3 years ago. Is that good? No. A lot's changed in the last 3 years. A lot's changed in the last 4 years of being a notary public. So need to take that renewal course, sit through that, learn all the rules of the road, or refresh yourself on the rules of the road again, and pay attention. I always tell, pay attention. You got to take that course. You're responsible to know the information in it. If you go out and act as a notary and don't understand any information, that could jeopardize your ability to stay a notary. That's what it's there for. It's there to refresh. Folks say, I've been a notary a long time. What do I need a course for? Well, that might be true, but the law today is much, much different than the law even 5 years ago, right? Significant changes to the law starting October 1st, 2020, and then more changes since, right? So it's been an evolving set of laws and regulations in the last 4 years. So important to learn those and act on those, and really every 4 years anyway, right? We don't think about things as much, maybe over the course of time. So it's good to get that refresher before you go back and renew again. Initial applicants have to complete a course of study and an examination. It says by the Secretary of State, but really by the Secretary of State or their designee. We have a list of authorized course providers that you can take a class from. Some are online, some are in person. Some cost more, some cost less. Sliding back to this page right here, if you were to click on the new notary information or renewing notary information links, one of the items on those checklists, step by step, is about taking the course of study, or if you're new on a course of study in the exam. And there's a link there that provides the links to our authorized providers pages. And you can pick from anyone on that list to take the course of study or the course of study in the exam. It's up to you to do the research on those and find which one works best for you. Some online, some in person, some more costly, some less costly. Entirely up to you. All of them qualify. And then commissioning. What's commissioning? It's a notary public. You are an officer of the state of Maryland, and you are commissioned by the state, and your commission gets sent to the clerk of the circuit court in the county in which you're authorized. So if you live in Maryland, it's the county in which you reside. If you live outside of Maryland, it's going to be a particular county that we designate. And you're going to go there and you're going to take the oath of office and receive your notary commission. That authorizes you. Once you've taken the oath of office and you receive your commission, you're now authorized to perform notarial acts. You got to get commissioned before you can notarize, though. It's not just getting the approval email that says you've been approved. That email tells you then to go to the clerk of the court within 30 days. Got to get there within 30 days to take the oath of office and get sworn in. You got to take that oath of office every time you're commissioned. So every time you apply or renew and you're approved, before you can act on that renewed commission or that renewal application, you have to go to the clerk of the court and get sworn in and take the oath of office for that next commission. every 4 years. There's no exceptions. Um, sometimes, again, life gets busy. We forget. Every now and then I get a person I'll talk to. They've been a notary 10, 20 years. They've renewed 2, 3, 4 times, and they forget. All of a sudden, they had to go to the clerk of the circuit court every time. It's like, I never went. I promise you did. Every 4 years you go, right? That happens. Life happens. So you get there every 4 years, and you have to pay them to get sworn in there. That's a fee payable to the clerk of the court, not the Secretary of State. So it's different than your application fee. And again, you must be sworn in within 30 days of the issue date of the commission. The issue date is the same date as the approval email. So when you get that email saying you've been approved, you got 30 days to go get sworn in. You got 30 days from the date of that email we sent you to go get that notary commission so that you can be an active notary. Important to do that. If you do not get there within 30 days, that commission is revoked. You would have to reapply. We don't want you to have to reapply. That's what the law says, though, right? So help us help you get there within 30 days. Nobody enjoys reapplying and paying the fee for the application again. We don't enjoy asking you to do it either, right? And everybody, how many people believe us when we say that? But it's no fun for us, right? So get there within the 30 days so that the commission's not revoked, so that you don't have to reapply per the law. So there's a few other things here when this is specific to notary fees. This has nothing to do with being a title insurance producer. This is just you're acting as a regular notary. These are the allowable fees. And we cover this topic on a lot of our town halls because we get a lot of people that have questions about the fees. This is what you can charge when you're acting as a notary, just as a notary. All right. These are your fees. You can charge up to these amounts, no more. Every town hall, we get some pretty creative questions about different fees. What about a convenience fee, an after hour, a service fee, a business fee, a technology fee, a this fee, a that fee? No, these are your fees. Right? $8 per notarial act. So if you notarize for 2 people, you watch them both sign, you acknowledge they acknowledge their signatures, or they swear to the truth of something, or you're just witnessing a signature. For 2 people, $8 plus $8, right? $8 per notarial act. Then you have some of these other charges in here on this page for additional copies of the same document notarized, or making a photocopy of a notarized document, what you can charge. Mileage, right? That's the mileage rate. If you travel, you can charge $5 plus the mileage rate, plus the notarial act. So if you were traveling, on the second town hall this year, we talked about fees in a lot more depth. If you were traveling to notarize for someone or for multiple people, it would be $5 because I had to travel, plus the mileage rate, plus $8 per notarial act. So in a scenario where you were driving to somebody to notarize for them in person, $5 plus mileage, plus $8 per notarial act. In a situation where you had to travel. No, there's no after hours. Again, I reiterate, no convenience fees, whatever fees. These are the fees you can charge up to. You can, and the phrase there, demand and receive up to, is a very important phrase. You can demand up to that amount. You can receive up to that amount. You can take less, but not more. Can't ask for more. Can't receive more. No tips, none of that stuff either. Get asked about that. I'm like, well, what if somebody wanted to call the tip? Can't take it. You cannot demand and receive more than that amount. Okay, these are the rates. These are the fees. If you're unsure of the fees, ask us offline. But as you hear my disclaimer on fees, every time I talk about fees gets longer, right? Because they've got a new convenient way to ask about charging fees and things of that nature. These are the fees. A notary is an officer of the state. You have a role as an officer of the state, and that's to notarize those documents. And these are the fees that are allowed to do that. And you'll see at the bottom there, the remote notary fee is now $30. Used to be $25. Recently went up to $30 last year. So $30 per remote notarial act. which is when you're using the remote online technology to notarize, a little different than your traditional notarial act. And so you can charge a little differently for that. We had an entire town hall last month about remote notarizations, where we talked about that subject in a lot more detail as well. If you're curious about what that is and what that entails, check that one out as well. So allowable fees, and I did keep the sample of the allowable fees travel scenario, right? So say you're asked to travel to perform a notarial act on a tangible record. You travel 30 miles for the performance of your duties. When the notary arrives, they notarize for 2 individuals, so they can charge the following: $16 for the notarial acts, right? 2 individuals times $8, plus $5, plus $20.10 for mileage, because it was 30 miles at that rate. So this is a good breakdown of a notary that traveled to notarize the document, what they can charge, the fee structure. This is based right off of this page, which is based on the law and the regulations that exist today. So the maximum amount that a notary could charge in this scenario is $41.10 based on this breakdown of fees. There's a lot of folks out there, they'll kind of term themselves mobile notary. It's not, it's more of, I'll call it an industry term. It's not a legal, or it doesn't have any meaning in the eyes of the law. Notary law doesn't care if you travel to do your duties or not. You're just a notary, and if you're a notary that travels, these are the fees you can charge. We've run across some scenarios where folks will say that I charge $50 to go this far, or $100 to go this far, and that's not how the fee structure works. These are the fees you're allowed to be charging somebody as a notary. There's a mileage rate and all that stuff. You can't charge. Again, demand and receive not more than. So you can't ask for more, but you could ask for less. You don't have to charge at all if you don't want to. There are some folks out there that don't charge to notarize. That's perfectly fine. And somebody will usually ask, well, what if I charge one person and not another? All right. We run into scenarios where maybe some businesses that have notaries on staff, they won't charge their customers, but they'll charge non-customers of that business. That's fine. Try to have some level of consistency to it. But you can demand and receive up to those amounts. So important, again, to drive that point home. So again, these are notary fees for your services as a notary public, not for anything else. Just as a notary, if you're being asked to notarize only, these are your fees. A couple other important points about notaries before we transition to the title insurance producer: journals. Got to have a journal. Got to keep a record. Every notarial act, no ifs, ands, or buts. Gotta have your notary seal, right? You got to put a notary seal in the document in order for it to be a completed notarial act. If it's not sealed, you didn't complete the notarial act. So your seal has to contain your name as it appears on your notary commission, the words notary public, and the county, or if it's Baltimore City, in which the notary is appointed. So if I was to say I was appointed in Baltimore City, I'd be Michael Schlein, notary public, Baltimore City, or City of Baltimore. That's what would need to appear on my notary seal. If I was commissioned in, say, Allegheny County, it'd be Michael Schlein, notary public, Allegheny County. You get the point, so on and so forth, right? One other important thing to mention is we see, I don't know why, but more recently we've seen some seals that say Baltimore City County. That's not a place. They're two different places. It should say Baltimore County or Baltimore City, depending on what courthouse you were sworn in at. So if you're commissioned in Baltimore City, it should say Baltimore City. If you were commissioned in Baltimore County, it should say Baltimore County, but not both. Those are two different jurisdictions in Maryland, two different clerks of the court. You got to have one or the other, not both. A notary's journal, again, every notarial act, even if you know the person signing the documents, even if you notarize for them every day, got to have a journal of every notarial act that you perform. And, you know, at second town hall here, we talked in great detail, not just about fees, but about notary seals and journals, and the lengthier bit of requirements for them. That journal, you must keep it for 10 years from the last dates chronicled in that journal. So if I completed my notary journal today and I filled it up, I'd have to keep that journal for 10 years from today before I can dispose of those records, right? So 10 years from the last entry in that journal, that's how long you have to keep your journal for. And those journals should chronicle every notarial act you've ever performed. Folks will often say, well, I'm done my journal. What do I do now? Well, if you're still a notary, get a new journal, start filling that one up, right? Keep your old one. So once you finish one, you start another one. And you keep your old one for at least 10 years from the time you finished it. Now, and one other important point on this too, don't want to forget to say this. It's your journal and your seal, regardless of who paid for it. You leave one employer and go to another, or you just leave your employer and don't go to another, whatever it is. Take your journal and your seal with you. That seal's got your name on it. It's yours. It's yours, right? Journal is yours. It's your record. You are the one. I always tell folks, well, so-and-so paid for it. I get it, but whose name's on that seal? Whose entries are in that journal? If something were to go wrong or somebody would have questions about something you notarize, who are they going to call, right? They're not going to call your old company. They're going to call you first because your name's on the seal. And it's Michael Schlein, Notary Public, whatever county I'd be commissioned in, right? Not Secretary of State, Notary Public, County of Commission. Your individual name's on there. It's yours. Take it with you. Plenty of horror stories about folks that left and they left their seal, and their seal the old employer just kept using it like they were still there. Don't let that happen, because when something does go wrong, we ended up talking to that notary, and sure enough, they had left there and they just didn't take their seal with them, and they got dragged into some mess that they had nothing to do with. And even then, like I said, seal and records, right? If even if it was a notarial act you did perform, should there ever be a question later about it, you want your journal there so you can refer to that, so you know who you notarized for, what you notarized, and when you notarized, and you could clear up any confusion on your end that may exist regarding that document that was notarized. General powers and duties, taking acknowledgments, oaths and affirmation, witness to or attest, certify or attest to a copy of a record in someone's possession, certified copy, electronic record into a tangible record, protests of a negotiable instrument. These are the main powers and duties. Third town hall this year talked about this in super great detail. We spent the whole hour on what is effectively breaking down this slide itself into different types of acts. So check those out. But these are what you're doing as a notary. Again, this is specific to being a notary at this moment. You can talk about title insurance producer stuff here in a couple minutes. Certificates, got to have notarial certificates on every notarial act now. If it's not there already, you're going to add one, right? If there's not already an oath or affirmation or acknowledgement or signature witness or attestation certificate already on the record in question, you got to attach one now. Every notarial act requires a certificate, and that certificate should be completed by the notary. There's a bunch of samples in the handbook. The samples in the handbook are actually pulled directly from the law. So if you wanted to go check out that link where you could find just the entire section of notary law, you just keep on clicking next to each section, and eventually you'll find the section of the law where those certificates are pulled directly from. So they're in the law and in the handbook. We're not that creative. We didn't make them up. They're just pulled straight out of the law. So if you're ever wondering why these, that's what the law says. But every notarial act shall be evidenced by a certificate, and you're completing that certificate contemporaneously with the performance of the notarial act. So same time and occurrence, contemporaneously. We're all here together. You're being identified by me. I'm watching you sign something, or you're attesting to your signature or acknowledging your signature, and we're completing this certificate at the same time that's happening. And then I enter it into my journal contemporaneously. I fix my seal contemporaneously, and then we're all said and done. And whatever happens with the document being happens, but the notarial act is occurring at the same time, place, and occurrence as with you signing it and things of that nature. So we're going to end on this slide. This is going to be our segue into Miriam's discussion here about title insurance producers. So there's a Maryland Insurance Administration Bulletin 16-34. And there was a prior one that was issued many years ago. This is the most recent one. It really explains when you need to have a title insurance producer's license versus just being a regular notary. So notaries that participate in real estate closings and settlements should be a licensed title insurance producer. And a lot of folks will use the term notary signing agent because that's what they get called in a different state or something like that, or that's a common term used by the industry at large. But in Maryland, if you're a notary that's participating in real estate closings and settlements, you would be acting as a title insurance producer in those situations, and that is a separate license. And it's kind of how I started with talking about it being a different license, covering what it is to be a notary. But next, we're going to cover what it takes to be a title insurance producer and points that go along with that. And this is the bulletin. If you're ever wondering, do I need to be a title insurance producer and not just a notary in this situation? This is the bulletin that covers that. It's found in our handbook. It is a important thing to know, right? Any person or company that provides escrow closing settlement services that may result in the issuance of title insurance must be licensed by the Maryland Insurance Administration as a title insurance producer. A notary who merely attends a real estate closing or a settlement that is conducted by another person or entity and who merely witnesses signatures in the consideration of the statutory fees that a notary is permitted to charge does not, in the view of the Maryland Insurance Administration, fall within the scope of the law that talks about this and is not required to secure a title insurance producer's license in order to perform such services. So, right, key there. However, if the notary is the only individual other than the buyer who was present, the notary is presenting documents for signature which may result in the issuance of title insurance, collecting escrow funds, or otherwise performing any duty other than witnessing a signature. It is the position of the Maryland Insurance Administration that the notary is performing escrow closing or settlement services that fall within the scope of this law and thus must be licensed as a title insurance producer to perform those services. Breaking that down just a little bit, if you're a notary and you're charging more than these allowable fees because you're doing a closing, you must be a title insurance producer. You're the only one there. You're not just notarizing. You must be a title insurance producer. And you must meet the requirements of such and get that separate license. This is where that line gets drawn between being a notary and being a title insurance producer. And again, this will get posted online, the recording and all. If you can't find this, if you got a handbook, it is in there. Check it out. But this is the bulletin that helps you differentiate between whether I'm a notary or a title insurance producer. But if you're doing those settlements and closings, settlement services, stuff that provides escrow, you're the only one there and you're charging a greater fee than a regular notary fee, sounds to me like you're a title insurance producer. You want to make sure you're licensed to do that. Just a quick contact page for the Secretary of State's office. At the end here, we'll have our contact information back up. If you don't write it down here, dlnotary_sos@maryland.gov is the best place to get a hold of us, dlnotary_sos@maryland.gov for general notary questions. So with all that being said, segue into title insurance producer, independent contractor, Miriam. It's all you. And thanks again for joining us.
Hi, everyone. Good morning. Thanks again for joining us. My voice is a little rocky this morning, but pardon me if I sneeze or something. I'm trying to recover from a cold. But I'll try to do the best that I can. Thank you for being here. So let's jump into the title insurance producer portion of this presentation. Can I have the next slide, please? So please be reminded that this presentation does not provide legal advice. You should discuss specific questions with your attorney, trusted financial advisor, or insurance producer. So these are the topics we'll be talking about today. I'll be more than happy to answer your questions at the end of it. But let's try to focus so we're able to finish what we're here to cover. Questions will be answered subsequently, and there will be contact information as well, where you can reach us. I think the SOS and the MIA as well. So we'll be talking about who a TIPIC is, who a TIP is. The license requirement for both is pretty much the same, but with just a little difference. We'll clarify those, the bonding requirements, the required appointments for a TIP and a TIPIC. We'll be talking about the TIPIC misrepresentation, and of course the last slide that Mike just talked about, we'll just kind of emphasize that at the end, and then the questions and contact information on how to send those questions and other useful references that might be helpful. The slide will also be made available on the MIA website should you want to refer to it in the future. So let's go right into it. Who is a TIPIC? The insurance article in section 10-101 defines who a TIPIC is, and it says a title insurance producer independent contractor means a person that is licensed to act as a title insurance producer, and as a result of that license, he or she is able to provide escrow, closing, settlement services that may result in the issuance of title insurance contract as an independent contractor for or on behalf of a licensed and appointed title insurance producer. And such person is, as a TIPIC, is not an employee of the licensed and appointed title insurance producer. It's a contractor of the TIP. Next slide, please. So we're also going to just try to clarify who a TIP is and who a TIPIC is on the slide. A TIP is a person, individual, or business entity that's a title insurance agency, including an attorney who solicits, procures, or negotiates title insurance contract for compensation or who provides escrow, closing, or settlement services that may result in the issuance of title insurance contract. I'm sure a lot of you are familiar with that, just to clarify that. And the difference between a TIP and a TIPIC is that a TIPIC is an independent contractor who could also include an attorney. Can we go back? Thank you. Who provides on behalf of a TIP escrow, closing, or settlement services that may result in the issuance of title insurance contract. A TIPIC is not automatically a notary. So a TIPIC must be commissioned as a notary in order to witness, document, or perform other notarial acts. So let's touch a little bit more into the difference between a TIP, a TIPIC, and a notary. A TIP typically is an employee, and a TIPIC must both be a TIP employee and a TIPIC must both be licensed to provide settlement services on behalf of a title insurance company that may result in the issuance of title insurance contract. A TIP and a TIPIC both must hold an appointment with a title insurer for whom the title insurance contract is going to be issued, may be issued in each transaction. Some transactions there may not be title insurance policy, but in most cases, there is the issuance of a title insurance contract. So a TIP and a TIPIC, TIP agency must hold an appointment with the insurer in order to conduct that closing or settlement services. A TIPIC and a TIP must also be commissioned as a notary in order to witness or perform any other notarial acts. So a TIP and a TIPIC is not automatically a notary. The TIPIC must be commissioned. And let's talk a little bit more. I'm sure you already know, but let's just add to that. A notary is a civil officer of the state of Maryland who is commissioned to perform notarial acts in order to solicit, procure, or negotiate title insurance contract for compensation, or to provide closing settlement services, the notary needs to obtain a title insurance producer license. I think Michael touched on that. And the bulletin also clarifies on, circumstances or scenarios where a notary must obtain a license in order to perform closings. I think we can go to the next one. So as some of you might already be familiar or aware, the pre-licensing education requirement that used to be a requirement for anyone who seeks to obtain a title insurance producer license. But effective October 1st of 2024, licensed applicants who are required to pass the title producer examination will no longer be required to complete an approved pre-licensing course or meet the employment experience requirement prior to taking the exam. Now, we all know that in order to do a lot of these things, we require some knowledge and, understanding of what is required and expected of a title producer. So while this is no longer a requirement, we strongly recommend that each applicant get some kind of learning, some kind of education about what is required before obtaining those licenses. But like I stated, it is no longer a requirement. But then we strongly recommend that. You could also refer to the MIA, Maryland Insurance Administration Bulletin 24-19 for more information on that. The bulletin is available on our website, and of course, this presentation will be made available if you want to get more information on the bulletin as well. So let's go into what some of those licensing requirements are. So a TIPIC and a TIP must be licensed by the insurance commissioner in order to conduct business in Maryland. In addition to passing the Maryland title producer exam, an individual seeking to obtain a TIP or TIPIC license must pay the applicable fees required by the insurance article. The provision of the insurance article relating to that is there. And the applicant must also complete and submit the NAIC uniform application for individual producers and submit a 150,000 surety bond or letter of credit, both of which must clearly identify the bonding company, the name and the bond amount. The coverage period must also state clearly that the state of Maryland is the obligee, and it must be duly executed by the principal, that's the title, the producer, the principal or producer and bonding company, or the attorney, in fact. If the applicant is an independent contractor, the title insurance producer independent contractor affidavit form must be submitted in lieu of the surety bond. So at the application, when submitting your application as a TIPIC, what will substitute your bond is the affidavit. So you'll be required to submit with your application the affidavit form. Next slide, please. So going further into what the requirements are, the bond requirements are, in addition to being licensed, a TIP agency is required to obtain, file with the commissioner, and also ensure that those bonds are maintained, the blanket fidelity and surety bond or letter of credit. An individual TIP employed by a TIP agency is not by themselves required to maintain a bond, as the TIP agency is obligated to ensure that there is a blanket fidelity and surety bond that would cover the activities of a TIPIC while they're employed by the title agency. But in submitting those, the application, the TIP is required to file the documentation showing that the TIP is covered by the agency and the required bond amount indicated on there. They must also file with their application an association or responsible individual designation form. For a TIPIC may, in lieu of the surety bond, file, like I mentioned earlier, a signed TIPIC affidavit that says the applicant will be a TIPIC working under the surety bond coverage of an identified TIP agency. We've had a lot of questions about, what is required to have a bond. A TIP is at liberty to secure a bond, but the insurance article does not require a TIP to secure a bond. but the tip can definitely, on her, based on their own discretion, decide to get a bond. That is absolutely okay too. But it is a responsibility of the tip agency to ensure that the TIPIC is covered by the bond. It is a joint responsibility of the title insurer, the TIPIC, to verify that the tip has the appropriate license to conduct business in Maryland and to maintain a bond that covers the action of the tip, employee, and the TIPIC. That kind of adds to what I just stated about the requirement for a TIPIC to maintain a bond. It is a violation of the Maryland law for a tip to use a TIPIC unless the tip's bond covers the TIPIC or the TIPIC maintains a separate bond. That further reinforces what I stated. Is the legal principle of the TIPIC. The tip is liable for all actions of the TIPIC that occurs within the scope of the TIPIC engagement with the TIPIC. So in some cases, TIPIC are contracted to conduct one closing, sometimes multiple, and over a period of time. But then the TIPIC and the insurer, they're all responsible for ensuring that, all the requirements, the bonds, the appointments, the license, all of it are maintained, not while, conducting the settlement, but before the settlement is being conducted by the TIPIC. All the requirements are required to be, should be maintained before conducting those services for the TIPIC. Next slide, please. So to further clarify on surety bond requirements, sometimes we receive questions regarding what the surety bond is and what the fidelity bond is. So let me just clarify a little bit on what that is. A tip agency applicant for a title producer license is required to file with the commissioner a blanket surety bond or letter of credit that will cover any person who suffers loss in the event the tip or its employee or the TIPIC converts or misappropriates money or money received or held in escrow or trust while acting as a tip. So this is what the surety bond covers. And this is also required that a tip agency maintains and provides coverage for the TIPIC. Next slide, please. The fidelity bond requirement. In addition to meeting the licensing requirement for a surety bond, a tip agency applicant for a title insurance producer license must also file with the commissioner a blanket fidelity bond covering the employer, that is the tip agency, in the event the agency suffers any loss as a result of the tip employee or TIPIC's conversion or misappropriation of money received or held in escrow. So I hope that clarifies the question as to what does the bond, fidelity bond covers, what does the surety bond covers. It is a requirement and this is essentially what it covers. Next slide, please. So the requirement for an appointment, we touched on that a little bit, but I hope this would further clarify that. The tip employee and tip agency must be appointed by the insurer, by the title insurer, in order to sell, solicit, or negotiate title insurance on behalf of the title insurer. Appointment is required. TIPICs must also be appointed by the applicable title insurer. I think a lot of questions have come from this, and I hope that this kind of clarifies that question too. We've received a lot of questions as to, okay, who is responsible for making sure I'm appointed before I, go into the settlement? This title company is asking me to conduct the settlement, but I don't know, do I have an appointment? It is your responsibility as a TIPIC and the responsibility of the title company to all ensure that the appointment is secured before the title agency uses the services of a TIPIC. Unless the TIPIC holds an appointment with the title insurer with whom the contract of title insurance may be placed. So a TIPIC appointment is required, and the tip agency must not use the services until those appointments are insured. The TIPIC agency and TIP are jointly responsible, like I stated earlier, for ensuring that the TIPIC's appointment with the title insurer with which the contract of title insurance may be placed. So it is a joint responsibility of the TIPIC and the TIP agency to ensure that those appointments are secured, not during, before the services is being provided by the TIPIC. Next slide, please. TIPIC misrepresentation. No person, whether or not a notary, who is not duly licensed, who is not a duly licensed typic, may hold themselves out to be to the public as a typic. It is a violation. Sorry, that provision is not there. I would update the slide and make sure it's there before we post it. It is a violation of the insurance article for a person who is not duly licensed, who is not a duly licensed typic, to hold themselves out to be, hold themselves out to the public as being a typic. It is an actual violation. So, but I'll update the slide and, make that information available. Next slide, please. So Michael has already touched on this, but this is an area that keeps coming back. And I hope that this presentation will clarify it. Keeps coming back in the questions, notary participation in real estate closing or settlements. It is clearly stated in the insurance article, section 10-101, that a person that, the provision requires that any person who is registered or any person or registered business or company that provides escrow closing or settlement services that may result in the issuance of title insurance must be licensed by the Maryland Insurance Administration. That is clear, I hope. A notary who merely witnesses signatures at a real estate closing or settlement in consideration of the statutory fee that notaries usually charge does not, in the view of the Maryland Insurance Administration, fall within the scope of this provision of the insurance article, and therefore is not required to secure a title insurance producer license in order to just witness signatures and perform other notarial acts during the settlement, as long as the activity of the notary is limited to just witnessing signatures. Then the notary is not required to maintain a title insurance producer license. Next slide, please. The Maryland Insurance Administration position, as outlined in that bulletin as well, that Michael made reference to, regarding closing, that region notary is the only individual other than the buyer present, and that person performed notarial duties beyond simply just witnessing signatures. Then the notary is performing escrow closing or settlement services within the scope of the insurance article, section 10-101. And therefore, such person is required to maintain a title insurance producer license. If you have any other question, I think this is clear, but should you need further clarification, feel free. We want to reinforce that because there has been a lot of misunderstanding regarding this. You have any other clarifying question, feel free to use the contact that will be provided to ask those questions. But the position of the Maryland Insurance Administration, as outlined in that bulletin, is still the same. It hasn't changed. A notary who is performing more than just witnessing signatures is required to maintain a title insurance producer license when conducting closings. Next slide, please. Thank you all. Here are some contact information. Should you have any other additional questions, the phone number is there, the email is there. Thank you so much for your time. I appreciate it. Over to you, Michael.
Yeah, thanks, Miriam. Appreciate your time here today. Just a couple of Miriam slides up for frequently used forms here, and some references. I'll leave this sit up for a minute while I conclude. So thanks again, everybody, for joining us. We're going to go, one of our folks here from Secretary of State's office, Robbie's going to read off. Robbie will catch you in a second here. Any kind of, if there are some common themes to questions for us, and we'll do our best to answer those here. If we don't get them covered here, the last slide I'll have up as Robbie's reading it off is the contact information for Maryland Insurance Administration and us at the Secretary of State's office for you to ask those questions to offline. so that you can get help in whatever your specific scenario or question is for us or the Maryland Insurance Administration, or maybe even both. So that slide with all the contact information, email addresses will be up, and we'll do our best to get back to you here within the next couple of days to answer those questions that you might have as either a result of this town hall or that maybe didn't get answered here during the town hall or in this little Q&A that we'll have here at the end. Thanks for joining us, and Miriam, thanks for your work on that and powering through that cold to stick with us today. We really appreciate it. And this is a reference page for Maryland Insurance Administration, their website and all. And Robbie, did you notice any maybe some common questions or themes that you thought we should cover again here before we finish up?
Yeah, thank you. So if you guys could address some specifics on if you need to be a typic or tip, and I'll give some of the questions that were asked. So do you need to be a tip or a typic for loan modification?
Loan modification. I guess the question then, and I'll do this slide back to the slide on that. Miriam, if you're like us, our answer is, I don't know. You probably should talk to an attorney. Because I guess it depends on what the documents say, right? Slide back to this bulletin here for a minute. So our answer is usually that. You might want to talk to an attorney or a title company or something, because my bet is it depends on what the documents say and are. Miriam, do you have anything to add to that?
I think you've pretty much covered it. Like you stated, if you have any questions, you will probably want to speak to an attorney. But definitely, if you as a notary, it's conducting notarial acts, and and the only one on the settlement, you are then most likely conducting settlement services and will do require a license. As long as you're doing more than just witnessing signatures, then it is very likely that you're conducting settlement services that require that you obtain a title insurance producer license. But feel free to ask, send those questions in. I don't know that the answer will be different from what I said, but send the questions in. And then, of course, feel free to speak to an attorney as well.
Yeah, and some of these are super delicate and super specific, and that's part of why I think in this situation, having them sent offline, one of the things that we've run into on occasion on our Secretary of State town halls, we've answered some questions and super specific information for a scenario, and somebody else is hearing that going, oh, okay, but the facts are different, or important facts are different. They may not be realized. So sometimes we are hesitant to give a specific answer because we can't give legal advice, and some of that may dovetail into that arena there. So what other questions we got, Robbie? Anything else?
Well, along the same line, I'm just going to reiterate the fact, reach out specifically, but it was asked a couple times if you're a notary and you're completing home equity line of credit or home equity installment loans, do you need to be a tip or a typic? Again, reach out case by case basis. So just specific documentation questions like that was asked a lot. But again, as Miriam said, I would recommend reaching out for those specific scenarios. There was a question when doing the notarial certificate. Do you sign as a notary public or do you sign as a typic?
So if you're completing the notarial certificate, you're acting as the notary in that moment, right? You're affixing your notary seal. So when you're completing a notarial certificate, you're acting as the notary. Is there a place to do something at the end, Miriam, usually for a title insurance producer? Do they have like a stamp or a license number or something they got to attach?
I am not familiar with that, but feel free to read. I'm not familiar that there's anything else. I know that for a title insurance producer who conducts a settlement, their information is required to be on that deed. that has been recorded and on the document that the TIPIC prepares, but I don't know that there's anything else. But feel free to send me an email with additional information to that specific scenario, and then I'll be more than happy to look into it and respond.
Right. Thank you.
And then a couple that just came in at the end. For the TIPIC exam, are there any study materials or a practice exam that is available that you guys issue? And also, is the appointment for a TIPIC required in writing?
Yes, there's an application. Let me start from the beginning of the question. I think your first question asked if there are materials. We do have vendors, and I'll have to reach out to our professional licensing unit for information about that. We do have approved vendors that provide those, materials and, pre-licensing class and all of that. If you could, send me an email with details of what your questions are, I'll be more than happy to, provide you with additional information regarding that and refer you to those approved vendors.
Thanks, Miriam.
Yep.
And then just looking at a few that came in after the presentation concluded. If one person has 5 documents to notarize, is the notary fee up to $8 times 5? It depends on if you are notarizing 5 signatures or if it is just 5 documents. Please refer back to the slide about fees. It is $8 per notarial act, not per document, not per signature per se. It is $8 per notarial act. So if you're doing 5 notarial acts on those 5 documents, then yes, you can charge up to $8 times the 5 notarial acts.
And there's adding on to what Robbie said too, if it's 5 of the same document, right, it's $8 per notarial act on the first one, and then $4 per notarial act on each duplicate thereof. So it really could be a couple different things here. And if you got multiple signers on each of the 5 documents, maybe it's 2 notarial acts on one and 3 on another, and so on and so forth, right? It's per, like Robbie said, per notarial act. And then are they the same? Is it the same document 5 times? Are they 5 different documents? How many notarial acts are you doing on each document? Don't think of it in terms of document. Think of it in terms of how many notarial acts am I performing on this document? And then that next document, is it a different document or the same exact thing that you just notarized, but just another original? And that'll help you. Up in this slide here, I ran back to that slide real quick for fees and such like stuff like that. And like I said, check out our website. We break down that information in our FAQs as well about what you can charge. But yeah, don't think of it in terms of documents. Think of it in terms of notarial acts. How many notarial acts am I performing on each of these documents? And then the only thing document related that's really relevant is it the same exact thing 5 times, or is it one or multiple, the same original, or is it different documents? And that'll dictate the answer to that question. And it really is variable on each situation. It does depend on those specific sets. And if you're not sure, reach out to us, the DLNotary_SOS at maryland.gov, or townhall.sos at maryland.gov with that question. And, I had both of them listed for us. The general notary questions, DLNotary_SOS at maryland.gov. For those moving forward, that's the best place to get answers to notary questions. If you have anything specific to the town hall here today, including that, if you throw it to townhall.sos at maryland.gov, we'll get that answered. I usually put people to DL Notary in the bigger picture because the town hall email address we're answering, leading up to and then after the town hall. We're not checking it every day in between all those town halls. Sometimes we get some long gaps between town halls. We're not in that townhall.sos, so you get a slower response time possibly. But we'll be active in it, obviously, over the next week or so coming out of this town hall. So either one, but in the big picture, go to DLNotary_SOS. Any other themes to the questions, Robbie?
Yeah, just segueing off of that, somebody mentioned that they usually contact the NNA, National Notary Association, for questions. Is that a reliable source? Yes, they are, but each state has different requirements and different laws. So for mail-in specific questions, as Mike just mentioned, I would recommend contacting our office instead of NNA for mail-in specific. Speaking of NNA, one person asked, is the NNA training meet the Maryland typic training requirements?
And that, yeah, I'll pile on it. NNA, if you do ask them, make sure you're telling them specifically to Maryland so they can help guide you. I know some folks have their membership. I know they're an approved provider for Maryland Notary course of study and exam. National Notary Association is definitely one of the authorized education providers. Are they also for Maryland Insurance? Miriam?
Sorry, can you say that again?
All right, National Notary Association, they do typic training. Are they an authorized education provider in Maryland for title insurance producer?
I'm not familiar with those license, some of those licensing requirements, but it's definitely something that I can get back to you on. I could reach out to our professional licensing unit for additional information on that.
Thank you. Yeah, send that one offline about whether or not they're typic authorized in Maryland to the enforcement.mia@maryland.gov. Thanks, Miriam. Any other ones, Robbie?
I think that's it that came in prior to the presentation. Just going through some of these other ones that came in after, like they both have stated, please reach out to either our email address here or Miriam's for your specific questions related to either typics or notary questions.
Thanks, Robbie. And we're going to wrap up here. So we're not going to have our usual type of thing here at the end. If you have questions that have not yet been answered, reach out to us by email at these addresses. Please remember that the contents of this town hall, the PowerPoint, are for informational purposes only, not legal advice. I know these are very closely related. We get a lot of typic type questions. I think it's important that folks understand the differences between the two. I can't thank Miriam enough for her time in her presentation today to help outline these things. To the extent that you think you might have a question for both, copy both of us on that email. Send emails to us here to get any other questions you have answered. And this will conclude our presentation today and our recording. And the recording will be posted online here within the next week or so. So you can watch this at any point in time coming out of this in the future. And, again, big thanks to our partners at MIA for working with us on this town hall. And we really appreciate everybody joining us today. Thank you, everybody.
Thank you, everybody. Thank you.